19C.
For the plaintiff.
All right, and who's here for the defendant?
Good morning, Your Honor. Lily Balick on behalf of the defendant. Balick spelled B as in boy, A as in apple, L-I-K.
I have a lot of people on this Zoom conference for a motion for summary judgment.
Yes, Your Honor. A lot of them are from my office. They're just learning and watching today.
Oh, okay. All right, so it's the defendant's motion for summary judgment. Go ahead. Oh, and
yes,
also
Your Honor.
Plaintiff has also filed one too. So go ahead.
Yes. Yes, Your Honor. So obviously we're here today on defendant's motions for summary judgment, which are predicated on an issue of standing and a condition violation of failing to provide a sworn proof of loss. Your Honor, as you've noted, plaintiff has filed a cross motion for summary judgment on these exact issues. So we have some clear legal arguments today and there are no factual issues. Therefore, we believe that summary judgment should be granted in favor of one of the parties. Briefly, Your Honor, this is a Hurricane Irma loss that was reported to UPC on April 4th, 2018. UPC undertook an investigation and had an adjuster inspect the property on April 10th, 2018. A representative from Roofing and Reconstruction Contractors of America, whom I'll refer to as RRCA, and the insured were present for the inspection. On April 21st, 2018, UPC sent the insured a reservation of rights due to their late reporting. In that correspondence, UPC included policy language for the duties after loss, including the submission of a sworn proof of loss. On June 27th, 2018, UPC received a report from FC Cruz Consulting Incorporated, prepared on behalf of RRCA. Thereafter, Your Honor, on August 2nd, 2018, UPC accepted partial coverage for the loss, allowing for ensuing interior damages to the property. However, there was no payment issued as the damage was found to be less than the $5,620 deductible. On August 16th, 2018, RRCA submitted its assignment of benefits to UPC for replacement of the roof, which was executed by Cassie Homer, the insured, on May 30th, 2018. On April 25th, 2019, plaintiff's counsel requested policy information and demanded undisputed payment. UPC then responded requesting a letter of representation. Thereafter, on May 22nd, 2019, UPC sent plaintiff's counsel and the insureds a request for information, specifically requesting a sworn proof of loss to be signed by the insured, as well as a status of the assignment with RRCA that was signed on May 30th, 2018. Plaintiff then filed suit the same day. Your Honor, we're going to begin with the standing issue. We believe that to be our most complex issue. Your Honor, it's undisputed that the insured entered into an assignment of benefits with RRCA on May 30th, 2018. It is also undisputed from the testimony of the insured that the AOB was to replace the property's roof. It is undisputed that the plaintiff filed suit on May 22nd, 2019, and that plaintiff's AOB is also for replacement of the roof. At the time the insureds executed the plaintiff's AOB on April 1st, 2019, they did not have any rights to assign. It is also disputed
because they didn't have any rights to assign because.
Oh yes, Your Honor, because of the RRCA assignment of benefits that was previously executed in 2018.
Okay.
Yes, sorry. Mm-hmm. For that reason, Your Honor, it's undisputed that standing cannot be cured during the pendency of litigation. It is required at the inception of suit. Therefore, Your Honor.
Okay, slow down. Yes. So I got a completely different picture from your motion, because from your motion, what I saw was that there was no standing because they breached the policy because they never provided a proof of loss on a timely basis. But what you're telling me is that they had already assigned their rights away prior to the current assignee, correct?
Correct, Your Honor. I believe we filed two motions for summary judgment. One is predicated on the standing issue and one is on the sworn proof of loss issue.
Well, I only saw one noticed, but that's okay.
Okay.
Which one are you which one are you referring to now with regard to
currently
this issue?
the standing issue, Your Honor, with the two.
I understand that, but which motion?
Oh, our motion for summary judgment.
Filing date, Ms. Balick.
Oh, they were filed on the exact same date, Your Honor. Give me one moment. It was filed on July 9th, 2020. I have it. It was stamped at 4/36.
Okay, got it.
Okay. Your Honor, as you know, plaintiff has filed their own cross motion. So the only argument the court needs to consider.
I need you to slow down, and I need you to lay this out a little bit better, because you've gone way too fast, and I was not aware you had two motions, because I frequently find double duplicate filings in court files. And so I did not even bother to read the other motion, because I read the longer one, assuming that you had misfiled it. So you have two motions for summary judgment filed, both in the same date as you noted, one at 4:36 and 13 seconds, and the other one at 4:36 and 13 seconds also. So what are the issues in each of those motions? One is that they had previously assigned their rights away to another company, correct?
Yes, Your Honor.
Okay. And then the other is what?
The failure to provide a sworn proof of loss.
Okay. All right. Just want to be clear. All right. What else do you want to tell me?
Your Honor, plaintiff, as you know, filed a cross motion, and their assertion is that the AOB provided by RRCA, which is the first AOB in line, is invalid. Your Honor, we believe in making this argument, plaintiff is effectively trying to skirt the issue of standing. Your Honor, this is flawed for a number of reasons. The contract that plaintiff's counsel referred to is called the Authorization and Understanding, which was executed on April 4th, 2019. And it does not invalidate the RRCA that was the AOB that was executed with RRCA.
Okay, well, but how does this affect standing? Because I mean, worst case scenario, they've got two AOBs out there, and isn't this more of a cross claim rather than one that affects standing?
Your Honor, we don't believe that it affects standing. We believe that the AOB is valid. I was just
well, then I thought you said that this affects standing.
Correct, Your Honor. So there is a prior AOB. Plaintiffs making the argument that standing is not an issue because the first AOB that was executed is invalid.
Okay, what I'm trying to figure out is from your argument.
Yes.
Why would this affect standing? Isn't this an issue of a cross claim versus standing? And if it was a standing argument, why didn't you raise it on a motion to dismiss? Why am I here on a motion for summary judgment?
Your Honor, we did, the previous counsel that was handling this matter did have a motion dismissed in front of Your Honor, which was denied on this issue.
So then basically that issue's been addressed, and then it doesn't invalidate the assignment, it just creates confusion. All right, so again, I'm not really sure, is there some case law that you can point me to that is instructive in on this particular issue?
In terms of standing, Your Honor, I mean, we've cited a numerous case law, including Kumar versus US Bank, just, stating that standing is required at the inception of lawsuit, and the fact that this AOB, which it was executed on May 30th, 2018, predates the plaintiff's AOB, which was executed.
Do you have some case law that addresses dueling AOBs as a standing issue?
No, Your Honor. I know that plaintiff did raise some case law, which we don't believe to be on point in terms of when there are two AOBs at issue, because this is an AOB, both AOBs are for the replacement of the roof. Okay,
so then the second, and who ultimately did the repairs?
As far as I'm aware, Your Honor, no repairs have been made.
Okay. So then in terms of the failure to provide a proof of loss, which is a breach of the policy, do you have any case law, and I would hope recent case law, on this issue?
Yes, Your Honor. We did a notice of filing of the Universal Property and Casualty case versus Monica Horn, which has similar facts.
When did you file that?
I think it actually was filed yesterday.
Well, then it might be in my email, but it's not going to be in the court file. I don't think I don't have it. Okay. So what's the case site?
It's Universal versus Horn, Your Honor. It's a case that came down.
Okay, I need the case. I need the case site of some sort.
It's number 3D19-1550, 2021 WL 191 546, and it's Florida District Court Appeal, January 20th, 2021, Your Honor.
Okay. All right. What else?
Your Honor, I'm not sure if you want me to proceed on my argument with the standing.
Sure. Go ahead.
Okay. Scroll up. Your Honor, I'm going to address the issue that was raised in plaintiff's cross motion. I kind of briefly said it, and you said that you can decide if you think I should continue it. Their argument is that they have standing because the AOB that was executed with RRCA is invalid based upon a contract that was called the Authorization and Understanding that was executed on April 4th, 2018. It's our position that that contract does not invalidate the AOB. Plaintiff is pointing to that contract as the alleged contract that's referenced in the AOB. However, Your Honor, plaintiff has provided no evidence to link these two documents together. In fact, Your Honor, if we look at plaintiff's motion, this is the only area that lacks evidence to support this assertion. So, Your Honor, if we were to assume in arguendo that the Authorization and Understanding is the contract referenced in the AOB, this Authorization and Understanding serves as a contract to enter into a formal third contract if the roof claim is, quote, approved. Your Honor, and approved here is ambiguous. That contract, the Authorization and Understanding, allows the insured to sign a formal contract with a scope of repairs, etc., and states, and I'm quoting, Your Honor, upon funding, I will execute a contract with our RCA LLC for the repairs and or replacement. By its own language, Your Honor, this document does not impact the AOB. If anything, this document is consideration for the AOB as it provides for 5 action items that RRCA will perform, which include inspection and documenting the condition of the roof and communicating directly with the carrier. Your Honor, RRCA did all of these things. Plaintiff's assertion that if there is no quote approval, the AOB is invalidated is incorrect. It merely prevents the insured from executing another third contract with our RCA. It doesn't magically null and void the AOB. Moreover, Your Honor, plaintiff has admitted by their own actions that our RCA's AOB is valid. Your Honor, on July 6, 2020, plaintiff obtained a rescission from our RCA. And Your Honor, there's no reason to obtain a rescission from an invalid AOB. Therefore, by their own actions, plaintiffs admitted that RRCA's AOB is valid. And due to all of the above, Your Honor, plaintiff doesn't have standing to maintain this action, and summary judgment should be granted in favor of the defendant.
All right, so I'm looking at your case, Universal Property versus Horn, which stands for the proposition that an insurer's payment or partial payment of a claim does not invalidate the affirmative defenses raised on the issues of failure to submit a sworn proof of loss. Not exactly on point, close, but not exactly. Anything in here that you want to tell me about?
Your Honor, no, that we just provided that case law in response to plaintiff's argument regarding the sworn proof of loss, that because the claim was denied, defendant didn't have the grounds to request a sworn proof of loss. However, partial coverage was afforded. And for that reason, the case facts are a bit analogous to ours, that you can file, you can request a sworn proof of loss. There's no waiver to request a sworn proof of loss just because coverage was afforded.
Right. Okay. All right. What else? Anything else?
That for standing, Your Honor, that's the extent of my argument before plaintiff. I was going to allow plaintiff to give me their argument and rebut them. However, if you like, I can also go into the sworn proof of loss argument at this time.
Well, I thought that's what you were doing.
Okay, that's no problem. I mean, as we've already discussed.
You have 2 motions in front of me. I'm going to hear your argument on both of them, and then I'm going to give Mr. Savala a chance to respond.
Okay, Your Honor. So as you know, we're here for the sworn proof of loss. The carrier sent correspondence to plaintiff's counsel, which we acknowledge. Although the insureds were copied on the letter itself, the correspondence was sent to opposing counsel via email and through regular mail. It's undisputed, Your Honor, that a sworn proof of loss was requested. UPC notified the plaintiff the day they filed suit that a sworn proof of loss was being requested. And rather than the plaintiff providing any sort of response, reaching out to the insureds, letting UPC know of the issue, there was no response, Your Honor, and a response here would have been reasonable. It's undisputed that we requested the sworn proof of loss, and UPC understands that the sworn proof of loss needs to be executed by the insureds. However, plaintiff's counsel knew of UPC's request and chose to file and maintain its suit. And Your Honor, as you know, with AOBs, plaintiff effectively steps into the shoes of the insureds, and in doing so, failed to help us investigate this loss, which was necessary in light of their demand for payment, which opened a supplemental claim. Your Honor, while we don't agree that plaintiff here has standing, for purposes of this argument, plaintiff, by virtue of its AOB, is bound to perform all conditions precedent prior to filing suit. Your Honor, by failing to provide a sworn proof of loss, there has been a material breach. There is case law that would allow plaintiff to overcome this breach had they submitted a sworn proof of loss prior to this hearing, or really at any point during the pendency of this litigation. And yet, Your Honor, there has been no sworn proof of loss submitted. Your Honor, we've already spoken about the Universal versus Horn case, so I don't need to go back over that. But basically, Your Honor, prejudice is presumed to the insurance carrier. And once you have found that there was a material breach in failing to provide a sworn proof of loss and see that the plaintiff has failed to provide evidence to overcome this presumption of prejudice, summary judgment should be granted in favor of the defendant.
All right, Mr. Saval, response?
Thank you, Your Honor. And I will address the standing issue first. And I believe Your Honor has already basically said that this argument was previously brought in a motion to dismiss, which was denied. But to the extent that the issue remains, the case law that counsel was referring to, there are two cases, one out of the second district, which really set the standard on this when there are dueling assignments of benefits.
What is the case?
Nikon versus Homeowners Choice, which is 249 Southern 3rd, 681. It's cited in both plaintiff's cross motion as well as plaintiff's response to defendant's motion for summary judgment. And in this case, there were two assignments of benefits that were both executed for the same claim. In that case, they pertain to different scopes of services, which were clearly performed already when the payment was sought. And what the second district said was that these were limited assignments on behalf of each respective contractor for the scope of services performed pursuant to the terms of the assignment. And the proposition, there's basically two responses of how that impacts this present circumstances. The prior assignment to RRCA in April of 2018, it does not identify, actually it limits the scope of services to the assignment to the scope of services that are rendered by RRCA, which is undisputed. They have not performed any replacement or repair services by both actually the corporate representative for the defendant as well as both insureds have said that unequivocally there have been no services provided or repair services. Whereas there have been repair services provided by Universal Contracting so far. They have not performed the entire roof replacements yet, but they have performed services to an extent to the roof under their assignment, which was in April of 2019. The other issue is that it is not clear from the RRCA assignment what the exact scope of services. They never prepared an estimate for the service that they would do, nor did they prepare any. So it's basically that there's no. It did not rob the insureds of their ability to convey an assignment to Universal after the claim was denied. Importantly, the authorization and understanding that counsel is referring to is a document that's actually referenced in the RRCA assignment as defining the scope of services to be performed by RRCA. And it says that they will inspect, obtain an agreed price, and proceed with undefined repairs or replacements within funding. But importantly, that document says that I hereby award the contract contingent upon approval of my insurance company. And it further says, I'm quoting from that document, Contingent means that if there is no approval, there is no contract. The insured who signed this agreement with RRCA said that her understanding of that was that if it was not funded, she had no contract with RRCA. She's had no further contact with RRCA since the claim was denied. So one of the things that the second district said in that Nikon case that I previously identified was that the totality of the circumstances is relevant to determining what the exact scope of the assignment is. And in this case, they didn't replace the roof. They didn't have any involvement other than getting this document signed. At best we might have two assignments, but they clearly don't pertain to the same scope of repairs. And notwithstanding, Universal has since, Universal being the plaintiff, has since done certain repairs on the roof under their assignment and has brought this lawsuit. So I think that under the case law, and I will just briefly address one additional case from the fourth district. It found the same thing, but did a little bit more in-depth analysis of the actual language of the assignments, and that is Sadiq. I will spell that S-I-D as in David, I-Q versus Tower Hill, and that's 276 Southern 3rd, 822. It relied on Nikon, and again, just found that it was unambiguous intent of the parties to limit the scope of the assignment to the work performed. So we don't have work performed by RRCA in this case.
All right, you're going to address the proof of loss now?
Yes, Your Honor, and I think that is actually the simpler issue because the defendant has raised this issue as a condition proceeding, that is sworn proof of loss from the insured as a condition proceeding. Well, as stated in the plaintiff's motion, the sworn proof of loss came the same day from defendant as the lawsuit was filed, but it was 3 hours after the lawsuit was filed. So that alone, I would think, would make it not a condition proceeding because it was requested after suit was filed. But even if that argument does not take the day, then it was requested. It was never requested from the insureds themselves. They both testified that they had never received a request for a sworn proof of loss from the defendant, which under the policy language of this particular policy, it's not an automatic requirement to provide a sworn proof of loss when there is a loss. It's only once requested by the insurance company. So it was never requested of the insureds. Instead, it was only requested of the plaintiff, which is the assignee, after suit was filed. And I have case law from the second and the fourth that address the issue of stepping into the shoes by assignees. And when there is a duty under the policy, that is not something that is supposed to get that's transferable. That's still a duty of the insureds ultimately. So
okay, I don't buy that argument. That's not a viable argument to me. What I want to know though is why did you never submit a sworn proof of loss given all this time that you had to do that?
I
don't understand that part of it. All right, go ahead.
Thank you, Your Honor. And the case law I was referring to also says that when coverage is denied, as in this case, then there's a waiver of that requirement. That's Castro versus Homeowners Choice, 228 Southern 3rd, 596.
Yeah, but coverage wasn't denied in this case. And I think that the case cited by Ms. Perez is more on point with regard to that. That does not waive the insurance company's right to a proof of loss, partial payment, or partial acceptance of responsibility. And there wasn't partial acceptance of responsibility, even though they found it to be within the deductible. So there was a request for proof of loss. when it happened or didn't happen, I'm not exactly sure. And it's never been submitted, ever. So this seems a little odd to me. All right. I mean, is there any evidence in the record that you can point to that reflects that the proof of loss has been submitted?
No, Your Honor, the only evidence in the record is that it was never requested of the plaintiffs. The corporate representative for the defendant was asked about whether, because there was a CC at the bottom of the request for a sworn proof of loss to the insureds, but he was not able to verify that it was actually sent to the insureds, and the insureds themselves said that they had never received the request for a sworn proof of loss.
All right. What else? Anything else on these two motions?
From the plaintiff, I don't think so, Your Honor, unless there's anything else I can attempt to try to clarify.
It's not Ms. Perez, I'm sorry, it's Ms. Bielik. Go ahead, Ms. Bielik, response.
Thank you, Your Honor. I'll be as brief as possible. So first and foremost, Your Honor, if there wasn't a standing issue, plaintiff would not have gotten a rescission from our RCA. I think that stands for itself, but even still, plaintiff brings forth the Nikon and Sadiq cases, which we don't believe to be on point. In both those cases, there were two competing vendors for different services to be rendered. For example, in the Nikon case, that was for water debris and removal and asbestos remediation. Here, Your Honor, it's undisputed that the services to be rendered were for the roof. I pointed to the deposition of the plaintiff in our response to plaintiff's motion. And I can read from the transcript, Your Honor, if you'd like, but basically the insured stated that when she called RRC to the property, her intent was to repair or replace the roof. In fact, she also stated that there was nothing else that needed to be repaired or replaced at the property due to Hurricane Irma. And for those reasons, Your Honor, I think it's clear, both of these AOBs for replacement of the roof, there is no ambiguity as to what was being assigned and for what purposes and repairs that needed to be made. As for plaintiff's contention that the authorization and understanding nullifies the assignment of benefits, we've touched on this before. We don't believe that to be true at all. Those 5 action items were performed by our RCA. And in fact, in the AOB, it says that it gives the right for our RCA to file a lawsuit. Why would you file a lawsuit if the claim was, quote, denied or whatever, and the authorization nullified the AOB? They are 2 separate documents. And as we stated before, plaintiff has provided no summary judgment evidence that this authorization and understanding is the contract referred to in the assignment of benefits. Yes, they were executed on the same day, but we don't have any concrete attestation that is the document that is being referred to. Nevertheless, Your Honor, in that authorization and understanding, it contains language that leads us to believe that there would be a third contract that would be executed had coverage been afforded for the roof or had payment been issued on that matter. I think that pretty much sums up our contention and our position on standing, Your Honor. As for the sworn proof of loss issue, I know the plaintiff has argued and the insureds did say during their deposition that they did not recall receiving this letter. That's a common answer and we understand that. However, we did raise the sworn proof of loss language in the reservation of rights correspondence that was sent to the insureds in April of 2018. So they were essentially put on notice, though it was included in that and within 60 days. And like we've made our argument, Your Honor, at no point has plaintiff attempted to give us a sworn proof of loss. And as you know, there is case law that would allow them to do that would correct this issue. Your Honor, for all of those reasons, we believe that both of our motions for summary judgment should be granted, and we thank you.
All right, well, your motion for summary judgment on the issue of standing is denied. Your motion for summary judgment on the issue of proof of loss is, however, granted based on the following. Number 1, the assignee steps into the shoes of the homeowner. Number 2, that there is no issue of fact that the request for proof of loss was made. That's been acknowledged by the assignee contractor they received a copy of it and they stepped into the homeowner's shoes. Therefore, they've received it, and there's no issue of fact that a proof of loss was never provided up until the date of this hearing today. So despite the fact that there may be some slight issue of fact as to whether the homeowner has received the proof of loss, there is no issue of fact that the assignee received it. And as counsel for the plaintiff pointed out, they definitely received a copy of it. And again, this is the kind of thing that could be cured, but it hasn't been, and this case has been going on for a while. So also I find that accepting partial responsibility liability does not obviate the requirement for the proof of loss. So Ms. Balick, you'll need to draft an order for me.
Yes, right.
And I find that it's fatal to the lawsuit. They didn't comply with a condition precedent of the policy. So basically judgment in favor of defendant.
Your Honor, we will.
Yes, please circulate it and then forward it to my office email address in Word format, please.
Absolutely. Thank you, Your Honor.
All right,
Your
thank
Honor,
you.
can I just ask one, because I don't know if Your Honor addressed the fact that it was requested after suit was filed, which means it can't be a condition preceding to the lawsuit.
I find that fact is not determinative. Those things passed like in the technosphere. So they made a request, but you guys were unbeknownst to them, in the process of filing a lawsuit. So as you pointed out, this happened by a matter of a couple of hours, if at all. So
Well, Your Honor, I'd just like to state for the record, there's a case, Willis versus Puff 736, Southern 2nd, 1272, which is cited in the plaintiff's cross motion for summary judgment. And that states that an examination under oath, in order to be a condition precedent, must be requested before suit is filed. So I'd just like to make that for the record.
all right. Also, your motion for summary judgment is denied.